In his response to the State Bar's letter of notice, Mr. Nifong gave a lot of conflicting, varied explanations of what had happened. He said he didn't realize that the information wasn't in DSI's report because he was so busy with his political campaign, that he had turned over the responsibility for providing discovery to assistants and legal assistants in his office. He said he didn't turn it over because he viewed the information about the DNA from multiple unidentified male contributors as non-inculpatory as opposed to specifically exculpatory. He said that it was not included because of privacy concerns. He gave a whole host of different explanations. After the letter of notice was served on Mr. Nifong, he recused himself from the criminal cases and the Attorney General's office took over the investigation. After reviewing all of the evidence, the Attorney General's office dismissed the charges and declared that Mr. Seligman, Mr. Finnerty, and Mr. Evans were innocent. The State Bar has charged Mr. Nifong with many rule violations, from making extrajudicial statements that had a reasonable likelihood of heightening condemnation of the accused and had a reasonable likelihood of prejudicing an adjudicative proceeding, to concealing exculpatory evidence, failing to provide information he was required to provide in discovery, making false representations to the court and the counsel. Any one of these, standing alone or taken together, would be conduct prejudicial to the administration of justice. The conduct, in fact, did not just have a reasonable likelihood of heightening public condemnation, but in fact it did heighten public condemnation of the three accused. It did prejudice the administration of justice, not just likely to, it in fact did. The State Bar's evidence will demonstrate that Mr. Nifong intentionally sought out the world's attention, went on television, talked about this case. When the world was focused squarely on North Carolina and its justice system, Mr. Nifong repeatedly and intentionally misled the media and therefore the public about a very serious case, caused racial unrest in Durham, intentionally concealed evidence to which he now admits the defendants were entitled, but which was extremely harmful to his theory of the criminal case, and made false representations to two judges in an effort to keep the defendants from discovering it. The harm done to these three young men and their families and to the justice system in North Carolina is devastating. The public perception is that justice can't be had in North Carolina unless you know how to play the shell game. If you can figure out how to play the shell game, you might get justice. The public perception is that the justice system in North Carolina has no integrity. This didn't have to happen, and the horrible consequences were entirely foreseeable.